Thank you very much. Please be seated. We'll go on the record in the matter of State of Utah versus Martin MacNeill. He is present with his counsel. The state's attorneys are present. We are outside the presence of the jury. Before we reach the substantive motions before me today, I'd like to make a record on a couple of things. First, the state, after showing the CJC interview of Ada MacNeill, the state made the child available for cross-examination, and the defendant chose not to cross-examine that witness. Is that correct?
Yes, Your Honor.
Thank you. And then, counsel, would you approach the bench? Turning to the motion to reconsider, the state moves the court to reconsider its decision not to admit testimony related to the defendant kicking his daughters out of the family home in June of 2007, and the defendant's proposing that the younger children be given to the Bledsoes, a family in California. The state argues that the defendant opened the door to this evidence when defense counsel cross-examined Sabrina. Specifically, on cross, defense counsel confronted Sabrina with her prior statement that on the day of Michelle MacNeill's death, the defendant was crying and said he, quote, he was really grateful that families are forever, unquote. The state argues that introduction of this statement makes the defendant an out-of-court declarant subject to impeachment like any other witness. In effect, evidence that defendant kicked out his daughters and offered the younger children to the Bledsoes is offered to contradict the defendant's claim to have been grateful that families are forever. Defendant argues that defense counsel used Sabrina's prior inconsistent statement to rebut allegations that the defendant was not sad or remorseful on the day Michelle MacNeill died. Sabrina's prior statements that the defendant was in fact crying bookend the families are forever statement. Defendant argues that the families are forever statement is not helpful to the defense, that it is only further evidence of the defendant's religious hypocrisy, and that defendant does not intend to ever argue that he was a faithful adherent to the principles and doctrines of the LDS Church, including the doctrine that family relationships are eternal. And on that issue, the court takes judicial notice that the phrase families are forever is a short-form reference to the LDS doctrine that family relationships are eternal. The court is not persuaded that the defendant has opened the door to admit this evidence. The statement was offered in the context of rebutting evidence that the defendant was not remorseful on the day of Michelle MacNeill's death. Even if the defendant did open the door, evidence offered to contradict the defendant's reference to families being forever is not highly probative, given significant other evidence of the defendant's religious hypocrisy presented in the case, and the defendant's never having claimed to be a faithful adherent to the LDS principles and its doctrines. The low probative value is substantially outweighed by the danger of unfair prejudice, as outlined in the court's prior ruling, as well as by confusion of the issues, waste of time, and presentation of cumulative evidence. Introducing this evidence will require further explanation about the nature of the argument in June of 2007, how long exclusion from the home lasted, and various reasons about why the Bledsoe proposal was or was not a good idea. For these reasons, the state's motion to reconsider is denied. I'd like to hear your arguments on the defendant's motion to strike the direct testimony of Jason Poirier. Would you like to be heard?
Yes, Your Honor. Briefly. Your Honor, if I may approach.
Yeah.
We just have two cases that we submit, and one of them, I believe, comes from the ALR article, which Your Honor referenced us to last night, and so we've already reviewed it, the Fountain v. United States case, a Fifth Circuit case, which seems to be cited fairly often in the little case law that there is directly on point. Pursuant to the ALR article, as well as most of the case law, there is an issue in relation to whether a witness's testimony should be completely excluded if he invokes the Fifth Amendment in relation to part of cross-examination, whether that would then in effect deny a defendant the right of confrontation, which is a fundamental due process right. The vast majority of the case law, and maybe even all of the case law that I can't think of an exception that we have reviewed in relation to this, where circumstances have been such that a court allowed a testifying witness for the prosecution to partially invoke to invoke the Fifth on part of his testimony, dealt with witnesses who had direct evidence in relation to the facts at issue. Most of the time they were co-conspirators, and so were involved in the offense and had more evidence than being a after-the-fact informant, particularly a 5-year after-the-fact informant. In this particular case, Mr. Poirier, he doesn't have any direct evidence in relation to the alleged offense. He came along, as I indicated, nearly 5 years after. His only evidence is his contention that Mr. MacNeill made some sort of incriminating statements to him while they were housed together in the Utah County Jail. Accordingly, the only potential cross-examination for the defense of Mr. Poirier is credibility issues and circumstances in relation to the statement that he claims was made. I think that in this particular case, that distinguishes this case from the co-conspirator cases in relation to witnesses taking the Fifth Amendment and still being allowed to testify, and it changes the circumstances in this case from just being a collateral issue to one where it is really dealing with the direct right of cross-examination.
It seems to me, as I looked at the cases, that that really is the question: is this a collateral question or not? And there are cases that say that impeachment based on bias, prejudice, and motive to misrepresent, those things are not collateral. The distinction is, general credibility goes to, is the witness a liar, versus bias, prejudice, motive to misrepresent. That issue is the witness lying right now on the stand? And it seems to me that this case is in some ways distinguishable, because you're dealing with an informant, essentially, for the government, you're dealing with motivations to misrepresent, and this may fall into that other non-collateral category. Is that essentially your...
That's our position, and I didn't find any case law that contradicted that position that was similar to the facts of this case.
Okay, thank you. From the state?
Your Honor, the state's position is that these are collateral issues. They are being used to attack Mr. Poirier's credibility. When it comes to his motive, I'm looking at a 10th Circuit case, United States versus Nunez. This was cited in the ALR article that the court suggested that the parties look at last night. In this case, the 10th Circuit held that a Sixth Amendment may be violated where a defendant is prevented because of Fifth Amendment plea from placing facts before the jury from which bias, prejudice, or lack of credibility of prosecution witness may be inferred. However, where a defendant had effective alternative means available to impeach the credibility of a prosecution witness, his Sixth Amendment right was not materially prejudiced. And I understand this to mean that if defendant in this case has alternative means of impeaching Mr. Poirier, both on his credibility and his motive, that are not subject to Mr. Poirier's claiming his right against self-incrimination, that the defendant's Sixth Amendment right of confrontation is not prejudiced.
What is the defense left with? That's another question I was thinking about last night. It seems to me that you're left with the probation violation examination and impeachment about the real estate transaction, and at that point you're about done.
I would add to that list, Your Honor, the retail theft charge that he had that was resolved through a Class A misdemeanor.
Isn't that basically the probation violation issue, that he had pending charges and they were resolved in some way?
Well, I mean, if the court is wrapping that up into a package, yes. But I see he's got a probation violation. That's one motivation. He's got a...
I thought the new offense was part of the alleged probation violation. Is
No,
that...
my understanding of the probation violations, there were two specific violations listed. One was the guns and knives, and the other one was just general untruthfulness.
And then he had the new offenses as well.
He had new offenses as well
Okay.
that he was booked into jail on. So there's the retail theft charge. There's the probation sanction that he was facing. There are several phone calls where he's talking to his wife about his importance to the case. And that goes to the defense counsel's theory that he thought he was immune from prosecution because of the information that he had. The plea agreements that he actually did enter to resolve the probation violation as well as the new charge, those are motivating. That's a motivating plea agreement. I mean, I know it's kind of wrapped up with the others, but I do think he can be impeached by asking, well, didn't you have a pending felony charge? And weren't you motivated in this case by the resolution of that charge? I think those are two separate grounds for impeachment. He's got his probation officer's reputation for truthfulness, which will be part of the defense case. And then on all of these matters on which he's expected to plead the fifth, his impeachment on those grounds really doesn't require his admission of guilt or his admission of responsibility. I think the fact that the defense is going to bring up the fact that he talked to his wife about for example, the scheme with the landlord or the scheme with the Rolex watches. One is he's already impeached on that, and he's prepared to admit that if he remembers that yes, he did have say those things in a phone call, but then subsequent questioning about whether he's guilty of those things, whether what level of responsibility he acknowledges, what explanations he might have for those. I don't think all that's required to impeach him, to show his motive. The motive that they're establishing, that he felt he was immune because of the importance of his evidence in this case, is established merely by the fact of them bringing it up. And then my understanding as well is that if he denies or if he pleads the fifth, they're going to play the phone call. So the jury will hear everything that is available as, I guess, evidence already, without requiring Mr. Poirier to divulge more and further incriminating himself, but also without denying the defendant his right to impeach Mr. Poirier on those subjects.
Or my understanding is that there are no phone conversations related to the Rolex watch scheme. Is that true?
That's correct. On that subject, I don't believe he mentions things in the phone calls. There are police reports, which I don't know if defense intends to admit those, to try to admit those or not, but Your Honor, and obviously the AL article, I think the vast majority of the case law on that says that, if we're putting Mr. Poirier on the stand to testify about things that the defendant said, incriminating statements by the defendant, and then he were to be crossed on that and he were to refuse to answer those statements for some sort of fear of violating his Fifth Amendment right, that is something that would lead to striking of the direct evidence or of his direct testimony. If, however, he's perfectly willing to talk about that, and he's willing to talk about other grounds for impeachment, but then on a certain few subjects where he's worried about self-incrimination, he says, look, I don't really want to go into details on that. I will acknowledge that there is a phone call where I talked about that. I think the defense need for impeaching him on those grounds is met, as well as his Fifth Amendment right being preserved. I don't think that leads to striking his direct testimony.
So it's your position that there are effective alternative means for cross-examination, even if Mr. Poirier takes the fifth, as he's indicated.
Right.
And that would consist of the probation violation, retail theft resolution, that he can be questioned about the phone calls and either admit or deny making statements. If he denies them, then he can be confronted with those directly. And that this really is more a collateral issue to general credibility and not related to the testimony, the substantive testimony on direct.
That's correct.
Okay. In your research, did either of you come across a Utah case? It's called State versus Leonard, that deals with this, at least in part, this issue of the scope of cross-examination. Did that come up?
I did not, Your Honor. I probably would describe that to a function of the amount of time and other.
It is. We're doing a lot right now, and
I did not find any direct Utah.
Okay.
Or directly on point.
There's, in Leonard, the Utah Supreme Court seems to suggest that this distinction between impeachment for general credibility and impeachment for bias and motive to misrepresent may not be so clear in Utah. They seem to use those terms interchangeably, and so I've been thinking about that case as well. I'd like to take a brief recess, review my notes from your arguments, and review my own notes, and then I'll retake the bench and render a decision. John, did you get a copy of that decision? Counsel, I indicated to you last week or 10 days ago that I would be issuing a written decision regarding the Ada MacNeill testimony. This is it. It will be made a part of the record. It essentially reflects the decision rendered from the bench, but I think it's an important issue and ought to be in writing.
Your Honor, before the court recesses.
Yeah.
Back, one thing I did forget to mention, back on the issue of Mr. Poirier's testimony. In alternative, the state does not believe that granting use immunity is required because, for the arguments that we've already discussed.
Yeah.
But if the court finds that the defendant's Sixth Amendment rights are impacted, the state is prepared, rather than forego Mr. Poirier's testimony, to grant him use immunity for the testimony that he might be required to give to be confronted.
And that does resolve the question. No. Have you discussed that with his counsel?
We have not, and
I mentioned to her about 5 minutes ago. She's aware of it, Your Honor.
Okay, does she need time to speak with him about that?
If that's the route we took, she probably would. Again, the state would prefer not to do that and would rely on its earlier arguments, but
Right.
while the court is recessed, if Mr. Poirier is here, we'll discuss that with him for the sake of efficiency.
Yeah, I think if you could do that, then we'd be ready to go. And I shouldn't be long. I've spent some time on this already. Thank you. Court's in recess.
All rise.